Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're discussing a court challenge alleging that Canada's voting system is unconstitutional. Canada uses a system called first past the post. In first past the post systems, the winning candidate is simply the candidate with the most votes. The successful candidate does not need to win a majority, they just need to win more votes than anyone else. 8 years ago, while he was running for Prime Minister, Justin Trudeau famously promised, as Prime Minister, I'll make sure 2015 will be the last election under first past the post. Now, there may be some uncertainty about when the next federal election will be, but there's one thing that is certain. The next election will remain under first past the post. Those who were hoping for a change to the system have now turned to the courts to try to get rid of first past the post. And they've brought a legal challenge, arguing that the system violates the charter. But could the voting system we've had since Confederation really be unconstitutional? Here today to discuss this is Chris Kinsinger of Jordan Honickman Barristers, the law firm representing the Canadian Constitution Foundation, which is the charity I work for, as an intervener in this case. Chris, thank you so much for joining me today. Now, our position at the Canadian Constitution Foundation is that first past the post is a perfectly constitutional system. But before we get into what we are arguing, can you explain the applicant's position? Why are they saying that this system that we've had is unconstitutional?
Well, thanks for having me back on the show, Christine. And as you noted, what the applicants are arguing in this case is that the federal electoral system, which is a first past the post system, violates the charter, specifically Section 3 of the charter, which guarantees the right to vote, and Section 15, which guarantees equality before and under the law and the right not to be discriminated against. So what they're essentially saying is that first past the post undermines effective representation. It undermines an effective vote, and in doing so, it undermines the right to vote guaranteed by Section 3. They're also arguing that it has a disproportionate impact on women and other minority groups, and therefore violates Section 15 of the Charter.
Look, I understand the criticism of first past the post. And, you know, you vote for a candidate in your riding, you vote for your MP or your MPP, your candidate loses. And some people say, you know, my vote was wasted. It was kind of thrown away. But is it really the role of the courts to intervene here, to strike this system down? To me, it seems like this is pure policy. This is just a policy question that politicians should be deciding, that the system, maybe it's not perfect, but it's not really the role for the court to intervene here. What's your view on that?
Well, look, Christine, I mean, courts do have a role to strike down laws that are contrary to the Charter, but our position as interveners in this case is that the Charter itself is neutral as to the voting system. And in fact, this is something that the Supreme Court of Canada has said. But more than that, not only do we say the Charter is neutral as to the voting system, but other provisions in the Constitution and in the Constitution Act 1867 actually expressly envision a first past the post system. So for that reason alone, first past the post is at a minimal level, it's a permissible system, and it's incorrect to state that the Charter can somehow override a system that has been enacted pursuant to other provisions in the Constitution.
Yeah, so for those of our viewers who are not scholars in constitutional law like you are, Chris, our Constitution is made up of more than just the Charter.
That's
it
right.
has there's a lot more to it than that. There's the Constitution Act 1867, which has these provisions that make reference to the system that we have now. Now, you know, the Charter itself, Section 3, may be neutral on what system we should have. But the applicants in this case, the organizations advocating for this to be struck down, are not neutral. They have a preferred system. What can you tell me in about a minute about the system they are advocating for?
So the applicants are advocating for some form of proportional representation, and there are different forms of proportional representation, Christine, but essentially what distinguishes a proportional representation system from a first past the post one is that the legislature more or less reflects the percentage of the votes that parties get on the whole in an election. That's very different from a first past the post system, which is based more on a constituency system in which each riding, that is constituency, sends one member of parliament to the House of Commons.
Up next, we're going to be discussing what arguments the Canadian Constitution Foundation will be making as an intervener in this case, challenging the first past the post system, and why our organization believes that this system is constitutional.